In this video, I'm going to be answering the question, what does a person accused of a crime do at an arraignment hearing? Now, I'm going to preface this by saying this is only for misdemeanor cases. And if you're charged with a felony case, this process will be a little bit different, and it will be at a different time than I'm explaining as far as misdemeanor cases. In a misdemeanor case, usually your arraignment is going to be conducted on your first court appearance. And at that arraignment, the judge is going to have to do specific things. They're going to give you a copy of the charging document. That can be either a ticket or a complaint filed in your case. The second thing they're going to do is either read those charges aloud to you, or you can waive reading. In other words, you can say, Judge, I'll go over that with my lawyer. You don't need to read out my charges here in open court. The next thing the judge will do is ask you how you plead. Now, in misdemeanor cases only, you'll be asked right then and there, do you plead guilty or not guilty? Most of the time, the judge is going to enter a plea of not guilty, or you're going to enter a plea of not guilty and consult with your lawyer before you do anything substantive on the case. The fourth thing that the judge is going to do is going to allow you to argue bond. If you ask bond conditions, like say the judge is going to either put you in custody or you're in custody, you can ask the judge to let you out of custody or establish a bond for you. Maybe that's an amount of money or just a signature. You can also talk about the conditions of bond. Sometimes it's common in some cases, like a domestic violence case, for a judge to enter a no contact order, where you are not allowed to contact a certain person. Now, in a practical sense, that person may be your wife, your friend, your girlfriend, or something like that. You may have an intimate relationship, or you're commonly going to contact them. In this case, if the judge enters a no contact order, that'll bar you from having any communication with that person via text message, email, anything. So now is your time at arraignment to ask for that bond to be modified. Say, Judge, we have these kids together, or we live together, whatever the reason be, to try to modify those bond conditions. The last two things that you're going to do at an arraignment hearing is the judge is going to give you a new court date. That's just to keep the case moving. Generally, that's going to be administered. One of the last things the judge does is says, you're going to come to court on this date. Also, they will ask you about a lawyer. If you're indigent, you don't have money, the judge will say, do we need to appoint a lawyer for you, or can you retain a lawyer on your own? In general, those are the only things that are going to happen at your arraignment hearing. If you have questions about this, if you are charged with a crime and you need a lawyer to either show up with you at your arraignment hearing or work on your case, feel free to contact my office.